Hi, this is the Business Guy. A judgment can be a serious and damaging event in a person's life, potentially affecting their finances, their credit score, and ability to retire in comfort. Well, the short answer to how long a judgment lasts is generally 10 to 20 years, with some states allowing for judgments to last for the rest of your life. The real impact of a judgment is more complex than just its duration. So in this video, we'll explore the definition of a judgment, the powers it grants creditors, the different types of judgments, and ways to protect yourself from them. So what is a judgment? A judgment is a court order that requires an individual, now called a debtor, to pay the opposing party, called the creditor. It's typically the final decision of a lawsuit filed by a plaintiff against the defendant. The judgment not only states the amount owed and often how it will be paid, but it also gives creditors the legal right to collect money from the debtor, seize bank accounts, real estate, automobiles, one's business interests, and other items of value. And by the way, if you appreciate this information, please click the like button below so YouTube promotes this video. Thanks so much. And subscribe and click the notification bell if you haven't already so that when more videos come out like this, you'll be up to date right away. So what powers does a judgment give to creditors? The powers that a creditor is granted with a judgment varies depending on the judgment. If a debtor does not show up to court, the court can issue a default judgment, basically meaning the creditor gets everything they ask for. If a debtor is present in court, they have the opportunity to defend themselves and offer compromises for a more manageable judgment. Some ways that creditors and debt collectors might be allowed to collect what they owed is if they are granted a default judgment, including property levies, where a creditor can request a writ of execution from the court, allowing officials to sell a debtor's possession at a public auction. A property lien can also be granted to a creditor, giving them ownership of specific valuables, like title to your real estate and involvement in the sale of property. Wage garnishment is another option, where a debtor's employer is informed of the debt and required to take a portion of their paycheck each week to pay the creditor. And lastly, a creditor may be given access to a debtor's bank account for direct withdrawals. So how long does a judgment last? The duration of a judgment varies by state and is determined by the statute of limitations for that particular type of debt. A statute of limitations is a specific time limit for the collection of a debt, and once it expires, the debtor no longer owes the debt. Now, the expiration time frame typically ranges from 5 to 20 years depending on the state and debt type. In California, for example, a judgment lasts for 10 years but can be renewed for another 10 for a total of 20. In Oklahoma, though a judgment expires in 5 years, the creditor can renew it every 5 years indefinitely. So you can have a judgment against you for the rest of your life. That is, a creditor can renew a judgment before it expires, and when they do, the clock starts all over again. In some states, statute of limitations might also be restarted if a debtor makes a payment or interacts with a judgment in any way. A judgment can also stay on a credit report for at least 7 years as mandated by the Fair Credit Reporting Act, even after the statute of limitations has passed or it's been paid off. So how do you avoid paying a judgment? If you're dealing with a judgment, there are several options available to you. You can hide in a hole for 20 years and hope that the judgment expires, or you can pay it off. And both of these options won't work well for most people. So the best option that we've seen is to live the asset protection lifestyle. That is, put your assets into a legal tool that protects them from creditors. Now, there are several methods of asset protection that people use, and some of these methods include, number one, an asset protection trust. In fact, our company sets up these trusts for clients that they use to hold and protect assets for the benefit of our client, who is usually the settlor who has us set up the trust and then funds the trust. It also offers asset protection for the trust beneficiaries, which is typically our client and our spouse and their named heirs when they both die. And we can design these trusts to be difficult or nearly impossible for creditors to access, and they might possibly provide some inheritance tax advantages as well. Number two, limited liability companies. Now, LLCs can be used to protect personal assets from business liabilities. This type of entity can provide a shield against lawsuits and judgments. Number two, homestead exemption. Now, this exemption protects the equity in a person's primary residence from creditors, and the amount of exemption varies by state. New Jersey and Pennsylvania offer no homestead protection. Florida and Texas provide protection for one's primary residence to a certain acreage limit. The problem problem is that most states offer very little protection for expensive homes. Plus, the homestead will not protect investment property. Number 4, retirement accounts. Funds held in retirement accounts, such as 401ks, may be protected from creditors under federal and state laws. Now, the problem is that there are limitations as to how much you can put into these plans each year. Number 5, offshore accounts, companies, and trusts. Now, setting up an offshore account inside of an offshore LLC, which an offshore asset protection trust owns, is the most powerful asset protection available. Your local courts do not have jurisdiction over our law firm trustee in the Cook Islands or Nevis, for example. In fact, we've set up more Cook Islands trusts than anyone in the world, and we know of no client who has lost money from a judgment in an offshore trust that we set up. Now, it's important to note that the effectiveness of these methods may vary depending on the circumstances and the applicable law, and it's recommended that you consult with a qualified attorney or consultant to determine the best course of action for your situation. This isn't legal advice here, but we do have attorneys and consultants on staff who might be able to help. Feel free to give us a call or fill out a free consultation form at assetprotectionplanners.com. So what are the different types of judgments? Here are some of the different types of court judgments along with examples of each. Number 1 is a default judgment. A landlord sues a tenant for unpaid rent. If the tenant fails to appear in court or respond to the lawsuit, the court may enter a default judgment in favor of the landlord, requiring the tenant to pay the unpaid rent and any other damages. Number 2, a summary judgment. A pedestrian is hit by a car while crossing the street in a crosswalk. If there is no dispute as to whether the driver was speeding and ran a red light, the court may issue a summary judgment in favor of the pedestrian, finding that the driver was liable for the pedestrian's injuries. Number 3, the interlocutory judgment. In a child custody case, for example, the court may issue an interlocutory judgment allowing one parent to have temporary custody of the child while the case is pending. Number 4, a final judgment. A judge may issue a final judgment in a breach of contract case, finding that the defendant breached the contract and order them to pay damages to the plaintiff. Number 5, declaratory judgment. A company is unsure of its legal obligations under complex federal law. It seeks a declaratory judgment from the court to determine its legal obligations under the law. Number 6, a consent judgment. In a civil lawsuit, the parties agree to a settlement and the court enters a consent judgment reflecting the terms of the settlement. Number 7, an injunction. A court issues an injunction prohibiting a company from using a competitor's trade secrets to develop a new product. And number 8, a default judgment. In a divorce case, if the defendant fails to respond to the lawsuit, the court may issue a default decree granting the plaintiff's request for divorce and other relief such as property division and child custody. These are some of the most common types of court judgments, and the specific types of judgments available may vary depending on the jurisdiction and the type of case. Here's some additional judgment that could be useful to anybody dealing with judgments and debt. One important thing to keep in mind is that judgments have a significant impact on your life beyond just financial consequences. As we said, a judgment could lead to wage garnishment, which could be embarrassing and cause tension with your employer. It can also impact your ability to get a car loan, buy a house, or save for retirement. Furthermore, if you're worried and think you might need asset protection, it's time to act right away. Ignoring the problem and hoping it will go away will only make things worse in the long run. It's also worth noting that not all liability is created equal, and some people are simply more likely to face liabilities that can result in judgments than others. For example, if you have deep pockets and obviously have the ability to pay, somebody's more likely to sue you, so you're much more likely to get into a lawsuit that results in a judgment. In conclusion, dealing with judgments and debt can be stressful and overwhelming, but there are steps that you can take to protect yourself and your finances. By setting up an asset protection plan early, you can avoid the worst consequences of a judgment and maintain a more stable financial future. Please like, subscribe, and leave your comments below. See you next time. This is The Business Guy.